Hey guys, it's Kathy. I hope you're doing well. Happy 4th of July. We made it. We made it past the 3rd of July, and if you haven't noticed, they they approved me. They said I can be monetized again. I have been decriminalized. Nope. What did he say, guys? Decriminalized? Was it decriminalized? If you don't know what I'm talking about, watch Judge Fleischer from a couple days ago on his stream, and you'll see. I am innocent. I have been decriminalized. Thank you so much for the wave of memberships. I don't even know how many it is because it won't tell me. YouTube takes days to count to, 20. Takes them a couple days. They use like marbles and an abacus. For you young people, an abacus is a calculator. It's not. It's not. Oh man. It's such a good day. Thank you. Thank you for the gifted memberships. Look, I can hold on. There's 17 of them, and they're all great. Thank you, Fozzie. Beautifully inappropriate. Donald, Rebecca, Sally, Darkest, Sally, Sarah, Rebecca, Darkest, Fozzie, 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 Tammy, Sally, Darkest. They're trying to make everybody green. Thank you so much, guys. Thank you. That's so cool. Everybody's green. Everybody's either green or blue. Hi, Nays. All right. Spade sent me our first clip. And it's only 20 some seconds long, guys. This is so funny. Oh my gosh. I was crying when I saw it. If you guys don't ever watch Steve Vincent, then you won't think it's funny at all. You'll just think it's normal. But it couldn't have happened to a better guy, I'm telling you. Here, here it comes.
Your Honor, on Mr. Williamson,
Oh my gosh, I've been talking to myself this entire time, and I am so sorry. And Miss Douglas, I really apologize. Court Magistrate, Miss Shive as well. I really apologize for that. I've been talking here to myself. Oh, sorry. Steve Vincent for the people recommending 10,000, 10%.
I can't imagine how hard that must be for him to know that no one heard him. All he does is talk. Oh, poor Stevenson. I love him. I love watching him and Philip Reagan. I know everybody hates Philip Reagan. I do not hate Philip Reagan. I think he's really good at his job and he tries very hard for everybody, every single person, even if they're a slime ball. But Steve Vincent and Philip Reagan love to talk. They love to talk, and no one heard him. Oh man, that's so funny. Okay. Okay. Now I had two options today. Oh wait, you see my froggies? You see my froggies? Me and Mina got me those froggies because I said when I took this picture, I just wanted a frog to be there so bad. See? See, look at this little frog. Isn't it so cute? She made me froggies. I couldn't fit this one and man, this is hard. This one at the same time because this software program wouldn't let me, so I had to cut them in half. Darn it. Darn it, darn it. But I love my froggies. Thank you so much. They look great. Okay, now back to the bad part. I had to make a decision today about the shooter case. Because, okay, that old laptop died. Like, it's there. I was able to charge it up to 7 full minutes today. All day I charged it, and when I turned it on, I had 7 minutes of battery left. And the reason why that's bad is because I missed her testifying. I have the verdict, I have the closing statement, so we're going to see the end of it. We won't see her testifying. Now, I'm not going to order a whole new power supply unit and a cord just to get her testimony. Just kidding, I did. It's not in yet, so I can't have it for tonight. So, I'm gonna play the rest of it. We're gonna see the rest of it today, and I'm just gonna throw her testimony on Patreon if anybody wants to see it later once I get my new power supply unit and install it into the laptop and get my new charger in the mail. We're gonna hear it. But for today, we're just gonna hear like closing statements and then the verdict. There's nothing else I could do. There's no way I can fix this, guys. It's one more poke before before it's all over. This computer, though, is not going to give me any issues. It's perfect. It's running perfectly. Ooh. Oh yeah, Patreon. Don't forget to cancel your Patreon membership. You don't want to have two freaking memberships because I know I always sign up for stuff and then I forget to cancel it. And then 8 months later, I'm like, I've been paying that for 8 months. Don't forget, go right now. Go to Patreon and cancel your membership if you have a membership here. You don't need two memberships. Cancel that membership. All the content on there is free. So you're all green. I see so much green. So if you have a Patreon membership and you're green or not green, get rid of it. All right. You done? Did you cancel it? I mean it. Go cancel it now. I don't want you to figure out 10 months from now. Darn it. I know I do that. Let's get to the shooter case, guys. Oh, boy. Get to the shooter case. I can't see chat without my glasses on today. Nope, 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 nope. That is not right. That's right. Never mind. That's not the verdict. Thought I was going to show you the verdict by accident.
You may be seated.
Okay, we're back on the record, State of Ohio versus Sierra Bailey. We've had some discussions, maybe an attempt for a possible resolution that didn't work out, but we do have to put that on the record. Ms. Bailey, when we put an offer on the record, we do it because we're required to. Supreme Court says we have to. It
Thank you.
There have been cases where someone claimed that the offer was not conveyed and they would have taken it had they known about it. And it went up to the Supreme Court and they said, well, to cure this, we're going to make sure the offer's on the record. It's the only reason we're doing it. My understanding is there was, after Rule 29 on count one, there was discussion of a resolution which led to an offer from the state to dismiss count two with a plea to count three. Is that the correct offer?
That is correct. I indicated that we would be willing to let Ms. Bailey plead to count three, dismissing count two with an agreement to community control.
Okay. And for the record, you conveyed that offer to Ms. Bailey, correct?
I did. I'll have her confirm that as well.
Okay. All right. Very well. I think we're going to need to look at these jury instructions after closing, but before the jury instructions, or we can look at them now.
I got rid of the jury instructions because they were very, 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 very boring. And they're going to go through them in their closing statements anyway. So the judge turned to the jury and said, she's not guilty because she's in this chair, and she's only guilty if they prove that she's guilty beyond a shadow of a doubt. And shadow of a doubt is not, more or less. It's beyond a shadow of a doubt, blah, blah, blah. So that happened for like 45 minutes. Or when I should back up. When they went through the jury instructions for what he said was well more than 45 minutes. And it was just going point by point on what the judge is allowed to say and not allowed to say to the jury. I cut that out.
Court of Common Pleas is again in session. You may be seated.
All right, ladies and gentlemen, you've heard all the evidence that we will hear in this case. We'll now move to closing arguments. Closing arguments, like opening statements, are not evidence. They're each attorney's opinion of what has been proven or not proven in the case, basically, what the evidence has revealed. The state has the burden of proof. The state goes first, then the defense, and then the state has an opportunity to speak last as well. So we'll proceed in that manner, and then I will instruct you on the law in this case. You cannot really start forming opinions until you've heard the law. All right. Ms. Nichols.
Ladies and gentlemen, you've now heard the evidence in this case. You've heard the testimony, you've seen the exhibits. So I want to talk to you a little bit about the instructions of law that the judge is going to give you here shortly and tell you how the evidence and the facts that you've heard throughout this trial prove to you that the state has met its burden in proving the elements beyond a reasonable doubt. Instructing justice. To prove to you that the defendant is guilty of obstructing justice, the state must prove to you beyond a reasonable doubt that on or about September 23rd, 2023, Sierra Bailey, with a purpose to hinder the discovery, apprehension, prosecution, conviction, punishment of another for, or assist another to benefit from the commission of using weapons while intoxicated, communicated false information to any person. So there are some legal definitions there that I want to talk about before we get into the facts. Purpose seems pretty straightforward, but the judge is going to tell you that a person acts purposely when it is the person's specific intention to cause a certain result, or when the gist of the offense is a prohibition against conduct of a certain nature, regardless of what the offender intends to accomplish thereby. It's the offender's specific intention to engage in conduct of that nature. This is intentional conduct, right? Sierra Bailey made a choice on September 23rd of 2023. So the offense committed by another. The state is not required to prove to you that the other person was in fact apprehended for, charged with, convicted of, or pled guilty to using weapons while
Oh my gosh, thank you.
You must find that using weapons while intoxicated was committed by the other person beyond a reasonable doubt. And to do that, you must determine whether the other person carried or used a firearm while under the influence of alcohol or a drug of abuse. Now, we've heard a lot of testimony about the drinking that was going on, the use of firearms that was going on. Dustin Bennett told you that he had been drinking. He told you that TJ Bailey had been drinking prior to using the firearms. He admitted they both shot firearms after consuming alcohol. And the defendant told you that her husband was, today she told you, on his way to being drunk. But she admitted that in a jail call with him on September 25th, she probably told him that he was wasted. There's no doubt that using weapons while intoxicated was committed on September 23rd of 2023 by the defendant's husband and by Dustin Bennett. The question is, for you to decide, is whether the state has proven to you beyond a reasonable doubt that when the defendant lied to Deputy Fox about knowing that there was shooting going on her property, whether she did that with the purpose to prevent him hinder his discovery of that crime that was occurring, to prevent him from figuring that out and probably placing them under arrest.
Rude.
So then you have to ask yourself, well, did Sierra Bailey know that there was shooting? And there is ample, more than ample, circumstantial evidence in this case that she did. 50 to 75 rounds were fired. Less than half a football field away from where she spent the majority of her evening. They were loud. Dustin Bennett told you he was surprised that people in the driveway said they didn't hear the gunfire. So then you decide that she did in fact know there was shooting, and she lied to Deputy Fox about it. There is no other purpose. She acted with no other purpose than to keep her husband and her friend from getting in trouble, because she knew they would get in trouble. Resisting arrest. The state needs to prove to you beyond a reasonable doubt that on September 23rd of 2023 in Warren County, Ohio, Sierra Bailey recklessly or by force resisted or interfered with a lawful arrest of herself. Again, there's a lot of legal definitions, although that may sound straightforward. Let's talk about some of those legal definitions. Recklessly. A person acts recklessly when, with heedless indifference to the consequences, they disregard
I know this one.
unjustifiable risk that the person's conduct is likely to cause a certain result or be of a certain nature. A person is reckless with respect to circumstances when, with heedless indifference to the consequences, the person disregards a substantial and unjustifiable risk that such circumstances are likely to exist. Force.
I really have a strong feeling that this attorney is personally attacking me. And now, can I bring a lawsuit? Because that was uncalled for and below the belt.
Any violence, compulsion, or constraint physically exerted by any means upon or against a person or thing. Any. So what does it mean to resist or interfere? It means to oppose, obstruct, hinder, impede, or prevent an arrest by a law enforcement officer by the use of force or recklessly by any means, such as going limp or any other passive or indirect conduct. You saw Sierra Bailey's video. You saw Officer Luke Ratliff's video. They don't, I don't think exactly butt up in time, but one certainly leads into the other. You saw the force Sierra Bailey used in an attempt to turn away and prevent Deputy Fox from placing her in handcuffs. You saw the force she was still using to turn away when Officer Ratliff approached. You don't have to rely on anybody's statements related to that. You can see it with your own eyes. What is an arrest? There's an intent to arrest under real or pretended authority, accompanied by the actual or constructive seizure or detention of the person, and which is so understood by the person arrested. Deputy Fox is placing Sierra Bailey in handcuffs. He was clearly arresting her. And she knew it because she commented on it as he approached in her own video. And she sat on that witness stand and said, I knew he was coming to arrest me. And she didn't like it. You can hear in her video that that she is argumentative about it before he approaches. She intended to resist before he even made contact with her. The state must prove that the arrest was in the process of taking place when the resistance or interference occurred. He had one hand in a handcuff. It was absolutely in progress. And the state has to prove to you that this is a lawful arrest. It is a warrantless arrest. Deputy Fox certainly did not stop in the middle of that chaotic scene at 5274 Zor Road on September 23rd to go get an arrest warrant, to go write up charges, file them, and go get a warrant. He acted on the spot. So it's a warrantless arrest. So a couple of things must be true. The offense for which the arrest was being made was one for which the defendant could be arrested. The arresting officer had authority to make the arrest at the time and place where the alleged resistance or interference took place, and a reasonable law enforcement officer under the facts and circumstances in evidence would have believed that obstructing official business had been committed by the defendant. Well, the court is going to tell you that obstructing official business is an offense for which someone can be arrested. Deputy Fox is a public official, which you'll hear about in the definition of obstructing. He is a public official. He was on duty. He was in uniform. He was a part of an active investigation. He had authority to make an arrest on Zor Road that night. So the question is whether a reasonable law enforcement officer under the facts and circumstances and evidence would have believed that obstructing official business had been committed. So what's obstructing? The court is going to tell you that obstructing means without privilege to do so and with the purpose to prevent, obstruct, or delay the performance by a public official of any authorized act within his official capacity, did an act that hampered or impeded the public official in the performance of his lawful duties. And that is wordy and kind of circular. So the court's going to define a couple of those terms for you. Hamper or impede means to do an affirmative act. Well, an affirmative act is a statement to law enforcement. That is an act. She chose to speak with law enforcement and she chose to lie to law enforcement. That's an affirmative act. That disrupts, hinders, or stops the progress of the public official. Deputy Fox was there investigating a bullet that had entered the bedroom of a 4-year-old in the adjoining neighborhood. He'd had multiple reports of shots fired coming from the direction of the Zor Road residence. He was aware, although had not personally ever responded to, shots fired calls before at Zor Road, at that Zor Road address. He arrives and attempts to determine the source of the shooting. Sierra Bailey lies to him that night. And that obstructs his investigation. That hampers, hinders, stops the progress of his investigation. So what was her purpose? Her purpose was to obstruct his investigation because she knew what was happening back there. And especially once Deputy Fox told her that a bullet had entered a residence across the street, or in the next, not even across the street, in the next neighborhood, she definitely doesn't want Deputy Fox finding out that her husband's back there shooting, that her friend Dustin Bennett is back there shooting, because that's not good for them. Again, Deputy Fox was conducting his duties when he responds to Zor Road to investigate the source of that bullet. He's doing his job. He's just trying to do it well. There are bullets flying into homes, and he is there to stop that from happening. The state does not need to prove that Sierra Bailey was ultimately convicted for obstructing. Just that Deputy Fox, a law enforcement officer, Deputy Fox, it was reasonable for him to believe that that offense had occurred. He's there. He asks, are people shooting? Sierra Bailey says no. He asks again. Sierra Bailey says no. He asks again. Sierra Bailey says no. As she describes it, rapid fire shooting. He runs back there and finds people shooting half the football field away. He was absolutely under a reasonable belief that the elements of obstructing official business had been met that night. And Sierra Bailey sat in that seat and told you that she resisted his attempts to place her in handcuffs. Ladies and gentlemen, the state has proven this case to you beyond a reasonable doubt, each and every element of the offenses, and therefore we would ask that you find the defendant guilty. Thank you.
Thank you, Ms. Nicholson. Mr. Schuett?
She can. Where's Ms. Warner? I think she
We'll need to switch over to
Don't worry, he gets it. It just takes him a second, but not too long. We just get to watch him fumble around for a bit.
I think that's the issue. No, I didn't need to. I can try. I'm now unplugged.
For about an hour. Go make a sandwich, take a nap.
We did it yesterday. I worked yesterday. Oh, there we go.
Oh, she's great. It works. It is still barely. Good morning, members of the jury. This is my last opportunity to speak with you, as has been discussed. So thank you for your attention. I know it's been a lot of breaks here and there, but this is the last time I'll be before you. And so I want to discuss your rights and oath as a juror. When you were sworn in, you said you would take this duty lawfully, that you would consider everything and deliberate only once the judge gives you the instructions that you have been given. And no one can take that away from you. You're about to participate in a very important part of our justice system, the deliberation and verdict. And your duty, when you take that oath, is to deliver a lawful verdict, which just means that you will deliberate, you will consider each other's conversation and the facts and the evidence and nothing else, and that you'll follow the law that Judge Peeler gives you. And part of that lawful verdict is that you hold the state to its burden of proof that you've heard multiple times beyond a reasonable doubt. And so I want to talk about that, the state's burden. The state must prove every element that you just saw of every charge, both count 2 and count 3, beyond a reasonable doubt. Not half, not a couple, every element of every charge must be proven beyond a reasonable doubt for you to say guilty. And beyond a reasonable doubt is the highest burden in our legal system. Millions of dollars switch hands every day on the slightest tip of a scale in a more likely or not standard. If the state of Ohio wants to take your children from you, it's a clear and convincing standard. That is still lower than beyond a reasonable doubt, the highest burden that our justice system has. And you can require of the
That
state
was
nothing
explained
less.
well.
Not that it maybe happened that way, not that it could have happened that way, not even that it probably happened that way. It must be every element beyond a reasonable doubt, where the answer is not guilty. So I told you at the beginning of this that a lot of this would come down to what Ms. Bailey knew and when she knew it. And that's still true. So what did she know? Well, we know she went inside of her home to put her infant daughter to bed.
Yes.
In a somewhere of a half an hour range, but it was still dusk, which is a good measuring point because when she came back out, it was dark. And we also heard from Dustin that at dusk is when they went in, around that point, they went in to do the cake. And that no one had gone back to the hay stalls at that point to shoot. So when she goes into her house, it's around dusk. Everyone was at or near the fire pit in the cornhole, but anyway, near the driveway. Nowhere 50 to 75 yards back towards the stalls. Most importantly, no one was shooting. No one was even discussing the concept of using firearms when she goes in to put her daughter to bed. We heard that the rest of the group goes in the bar room. They have their cake. They sing happy birthday. We heard they were spraying each other. But all of that was confirmed by the state's own witness, who is one of the shooters. So certainly he knows the timeline of when he would have been shooting. And it was all after Sierra Bailey went inside her home. And Dustin said he didn't see her come back out. He didn't see her again until he had been arrested by Deputy Fox. She said she fell asleep. And Taylor told you yesterday that that's true. She went in to see what Sierra was doing and that she was asleep. She said her name. She didn't respond. So she left. When Sierra wakes up, it is now dark outside. Not dusk, but dark. So it's been at least a considerable amount of time, whether it's an hour and a half.
Thank you, Linus.
What matters is there's a passage of time that's pretty substantial. This isn't a cat nap of 5 minutes. She goes back outside with her daughter. Taylor is gone. And then Deputy Fox arrives shortly later. That's what she knows at that point. No gunshots have been heard when she wakes up with her daughter to walk outside and talk with Matt Sherwood before Deputy Fox arrives. And Deputy Fox confirmed that because he didn't hear any gunshots in that period of time either. He's at the Hannigan residence dealing with that, which is obviously a very serious situation. No one is disagreeing with that. But he doesn't hear gunshots. He's driving over to the Zora residence, no gunshots. He gets out of his vehicle, no gunshots. He's asking questions, no gunshots. So what they're hearing is lining up at this point. So no gunshots that he has heard until they hear that rapid fire while they're in the driveway together, Deputy Fox and Sierra. And that is backed up too by Deputy Fox's own actions or lack of. He said, I didn't come in with lights and sirens because I wasn't exactly sure where the shots were coming from, right? So he's still actively investigating. So if he didn't know exactly where they were coming from, he hadn't heard them, right? And so that also backs up what Sierra told us.
Kind of also backs up the fact that she obstructed when she said there was none.
Yeah, the prosecution wants you to assume that she heard these gunshots. But that might actually
I heard
be
the gunshots from Pennsylvania.
Some hindsight bias by Deputy Fox, right? Because he hears gunshots once he gets to the property.
Thank you, Cha. Thank
He knows,
you.
and we'll discuss whether or not Sierra knew this, that a bullet, at least one, had gone into a home. And so he is convinced, well, then she must have heard gunshots too. And in fact, Ms. Nicholson told you 3 or 4 times in her closing that the defendant lied when she said she didn't hear gunshots. That is an assumption. What evidence did you hear that Sierra Bailey heard a gunshot? None. What Sierra Bailey didn't know is also important, which is she had no idea what had happened at the Hannigan residence, that there's an ongoing investigation, where her husband and Dustin were after she wakes up and comes outside, and what they're doing. which is that they're at the stall shooting. She told you that if she had known that, she wouldn't have stopped it herself because she didn't want anyone shooting firearms if they had been drinking. So when did she know the shots were fired? Well, she heard them when she was standing with Deputy Fox. So the same time he heard them, she heard them. So they're learning at the same time that there is active shooting on the property. You can't just assume that because gunshots happened and they're loud, that means Sierra heard them. You can't. The state has to prove beyond a reasonable doubt that that's true. And circumstantial evidence, yes, you can consider it like direct evidence, but this isn't just, well, a noise happened, so that person who's in the corner of a house with ambient noise around them, asleep, must have heard that. And that's common sense. I'm sure if not you, someone you know has slept through a thunderstorm that was very loud. Or traffic. I've been to New York City, it's loud. Sometimes you can hear it, sometimes you can't. We sleep through things all the time, especially when we're tired. Taking care of a baby, nursing, all of those things happen that we sleep through things that maybe you would think had I been awake or paying attention, you wouldn't. Fire alarms in college, these things happen. It is not in any way an absurd concept that someone is in deep sleep when there's white noise around them, behind oak doors, away from everything that's going on, with music and everything else, that they didn't hear a noise. Even a loud noise that is 50 yards away. There's no question that the music was still playing in the driveway and she fell asleep during that. So you can't just assume she heard it. They have to prove that she did because they're saying her statements that she didn't know about the shooting is a lie. That is why they need to prove it. So count 2, obstructing justice. They have to prove beyond a reasonable doubt that Sierra acted with a purpose to hinder the discovery, apprehension, prosecution, conviction, or punishment of another person for the crime of weapons while intoxicated. We'll come back to this, but the key phrase here is with a purpose to. It was her intention to do these things. Or that she had the purpose to assist someone in committing weapons while intoxicated.
Her husband.
And then finally, that
and his
her
friend.
communication when she had that intention and purpose was false to any person. In this case, it's Deputy Fox.
Thank you, Fozzie.
But they have failed to prove beyond a reasonable doubt that Sierra knew anyone was using weapons while intoxicated. I'm not going to stand here and contest that Dustin and TJ were intoxicated. It sounds like they were. I mean, Dustin told you that he was. Take him at his word. But they have to prove she knew about it. She can't lie about it if she doesn't know about it. And they haven't proven beyond a reasonable doubt that she even had knowledge that there were people using any firearms, whether they were sober or impaired, until she heard the rapid fire when she was outside and awake. Even if she saw her husband and Dustin consume alcohol before she went inside, which Dustin told you no one was discussing firearms, no one was shooting firearms. Sure, she can anticipate they might have still been drinking, but that doesn't mean that the knowing that they were shooting has been proven beyond a reasonable doubt. And that's important because you can't convict her if that isn't proven. And there's no evidence that she knew that. None. Not even circumstantial evidence. Again, they can assert all they want that she must have heard it, but you can't go based on assumptions. Assumptions aren't evidence, and they don't allow the state to meet their burden of proof. It's not good enough to say she could have, she might have, she even probably heard it. They have to prove beyond a reasonable doubt she had heard.
Thank you. Thank you.
What we heard was that she was asleep. She was back in her room before anyone had even discussed or gone back to the hay stalls or fired a weapon. So not only do they have to prove that knowledge, they have to then prove beyond a reasonable doubt that she acted with a purpose to hinder Deputy Fox from discovering that that crime was occurring. that is the shooting while someone was intoxicated. Her purpose in answering Deputy Fox's questions was to be responsive to the question, where are the idiots shooting? I don't know. That is responsive. If she's trying to hinder, she could say something along the lines of, and I know the contention here is that she said no, she says, I don't know. But if she actually lied, sure, but there's no proof that she did because she didn't. She was responsive and honest. She said,
I did
don't
too.
know. And then the answer of they could be anywhere on the property if they're shooting is also true because she hadn't heard any shots. So if it were true, then that's where it could be, right? Anywhere. Now, here's the other catch-22. Let's assume she had just said, well, normally people shoot at the hay stalls. And so though I haven't heard anything, that's where they're at. And she had just said, at the hay stalls. Well, let's assume they weren't there, but she guessed. Well, then she could still be charged. Under this theory, she would still be charged because somehow that delay, because then he would have gone to the hay stalls and they weren't there. She answered responsively and honest, which is, I don't know. They could be anywhere if they're shooting.
Thank you, Rebecca.
There is no evidence that she had a purpose to delay Deputy Fox when she answered, especially a crime she didn't know was occurring.
Todd,
Dustin
you're
Bennett's actions on that
green.
night are his own. His decision to drink and go shoot a firearm cannot be sent over here to Sarah Bailey unless she knew about it. And they haven't proven it. Same with her husband. Even if he pointed a weapon at the Deputy Fox, that is his decision for him to deal with, his own accountability and his own justice system to work that out. They haven't proven that Sarah Bailey knew any of that was occurring. And that is the important part here, because then she can't have a purpose to obstruct justice.
Hey, AC.
And much like the
Okay, guys, real quick. I have a link in one of my posts about AC, American Courts. One video is at 998,000 views. It only needs 2,000 more views to hit 1 million. Go to my post and click that link and get that post to 1 million, please. I mean, it's going to get there slowly, but man, it's so close.
she didn't have the purpose to hinder, she couldn't have the purpose to assist in the crime she didn't know was being committed. It's the same issue. No matter how you package the obstructing justice, she doesn't have the knowledge of it, and she didn't do anything to then hinder, because she can't act with a purpose to assist her husband if she doesn't know where he is and she doesn't know what he's doing. The same with Dustin. If she doesn't know where he is and she doesn't know what he's doing, she can't be trying to assist or have a purpose to assist. Again, you can't just assume she knew something. The state had to prove the knowledge, they had to prove the intent, they had to prove the purpose. They can't get by just saying, it's possible.
Sob sit, AC, sob sit.
The words matter here, and the purpose and the knowledge are very important.
The property was either 3 acres, 10 acres, or 100 acres. Because that's what I've been told. It was like this big on the paper.
And finally, they had to prove that Sierra communicated false information. The key word here being false, not true. I don't know. They could be anywhere on the property.
350 acres.
False. She didn't know, and they could have been anywhere. She did at no point gave a dishonest statement to Deputy Fox. Yet they're asking you to convict her.
Now
really
you're
just
both
because
lying.
Deputy Fox didn't believe her.
Nose are growing.
That's
Pants
why.
on fire.
It's not true in their eyes because Deputy Fox didn't believe her. It's not true in their eyes because later there was gunfire. But when she said those words, they were responsive to the questions, therefore not obstructing, and they were honest. So they can't be false.
Thank
Deputy
you,
Fox
Chris.
knew about the reports of shots fired. Deputy Fox knew about the bullet that had gone into the Hannigans. Sierra did not when she was making those statements to him. And when I asked Deputy Fox, we're going to come back to this concept for resisting. When I asked him, and he said, yes, I knew these things. That's why I thought she was lying. I said, well, what other facts did you have that she would have known that? He couldn't give you any because there aren't any. They didn't have a prolonged conversation, partly because then they heard gunshots and he ran to go deal with it. But he didn't ask, how long have you been out here? He didn't ask, had you been in the house? He didn't know she had gone to the store, didn't know that she had been asleep. And yet he instantly is like, she's lying because he knew there had been a shot.
Because she's
He
lying.
also needs evidence. And we'll come back to that. Just like now they need beyond a reasonable doubt, he also needed it at that time. So there was no communication of
Hi,
false
Monica.
information. Just because Deputy Fox decided not to believe her, didn't believe her, doesn't mean it was actually beyond a reasonable doubt false. Sierra knew that she had gone inside, fallen asleep, not heard any gunshots, come out, and it was dark, so much later. Deputy Fox didn't know any of those things because he didn't ask.
I'm
The
pretty
state has
sure
failed
it's
to prove
under a
every
quarter of a
count
mile.
of obstructing justice beyond a reasonable doubt. And so you must find her not guilty. The state's burden of beyond a reasonable doubt for count 3 of resisting arrest, as Ms. Nicholson
It changes
told
you.
that Sierra recklessly or by force resisted or interfered with a lawful arrest of herself. And so resisted recklessly or by force. You'll watch the video, you can see what you see, but she does raise her hand to Deputy Fox as he's coming. Now, we'll talk about it. She said, I didn't understand exactly what he was doing and why, but she does raise her hand as he's approaching. You can see that in the video. And then as her shoulder is twisted and dislocated, she bends forward. And she said she twisted to relieve the pain in her shoulder. That is your decision to make if that is resisting recklessly or by force beyond a reasonable doubt. When Officer Ratliff appeared on the scene, she doesn't struggle with him. Her hand then becomes behind her back. She gets handcuffed. She complies. She sits down. So there's certainly no other events once Officer Ratliff arrives that would constitute recklessly resisting or by force. She sat there until she was put in a police cruiser.
Thank you, Joey Cat.
The real focus here is, even if you believe that by force or recklessly she resisted, it still had to be a lawful arrest. We do not have to just bend a knee to unlawful arrests. It is an important word, and it's put there for a reason, that it's a lawful arrest. So break that down. An arrest requires proof that she understood what was happening to her. That was one of the elements.
It's
right?
very
important.
loud.
She wasn't being searched for weapons at that time. She wasn't just briefly being detained. I mean, she has to understand those things. That's what's happening to me. I'm being arrested. I'm being put into custody. And Deputy Fox admitted that he didn't tell her what he was doing. You hear that on the video as well. He doesn't. He walks up. And I understand there was a lot of adrenaline going. That's what he said. Right? He did a lot of things that was a little bit out of character, his use of language. He challenged someone to commit a felony. And so he forgot that part of the procedure. Okay, fine. But it's an important part of lawful arrest. And we can't just excuse that because he's got an adrenaline dump. And Sierra's mobile phone confirms that he didn't say that as he approaches to put her in cuffs. And so lawful. Police officers can't remove our freedom of movement just because. We have constitutional rights that we've talked about. We're going to be celebrating those next week. So we make sure that the government is not tyrannical and imposing their weight upon us and just locking us up or putting us even in custody for no reason. There must be cause, a probable cause, a justification. Now, typically you want a warrant. That's what the Fourth Amendment says, get a warrant. And I understand most of the time there's not time for warrants, and there certainly wasn't here. I get that. No one's asking that he stop everything and go find a judge and fill out an affidavit. That wouldn't have made sense.
They have
In
to
fact, most
wrestle
things,
for it.
on a day-to-day basis for police officers are warrantless arrests. But they still require a certain threshold of evidence to be lawful. They can't just be a hunch. An officer can't just say, you might be committing a crime, I just feel that in my gut, and arrest you. Can't do that. That's illegal.
Lawful laws. Thank you so
They
much,
can't
Fletcher.
even
Thank
do
you.
what's called a reasonable suspicion. Like, I've got 2 facts or so, and there's not a set quantity, but a couple of things I can point to. So I'm suspicious and I have a reason. That's not even probable cause. That is not enough to arrest you. Now, it's not the same as beyond a reasonable doubt to convict someone, but it's still a threshold that must be met. There must be a certain totality of facts that they can rely on to believe that a specific crime is being committed. Otherwise, they could just arrest us for no reason, and it wouldn't therefore be lawful. So a reasonable police officer, as the instructions that you're going to get, would have believed that the elements of obstructing official business had been committed. And Deputy Fox told you that the obstruction, when I asked, was at the driveway when he first arrived. That's what he said. Those were the facts that were rising to what he believed
Thank
were
you,
reason
Julie.
to lawfully arrest Sierra.
Everybody's going to be green.
Not what she did afterwards, but at the driveway when he pulled in. Those very statements that we've already talked about. So you'll get the instructions that obstruction of official business is the purpose to prevent, obstruct, or delay Deputy Fox. No one's going to contest that he's on official duty acting in an official investigation. And that he didn't act, that Sierra didn't act that hampered or
Thank you,
impeded.
Monica.
Both of those must be true, that she had a purpose to prevent and she didn't act to hamper and impede. Well, Deputy Fox approached her as part of his investigation, right? To figure out where the shooting was coming from. Her answers were responsive to his questions, and they were honest. So once again, the very same analysis that you did for obstructing justice on purpose and analyzing those words that she gave, it rings true here. Her answers were responsive. They were honest about what she knew. Therefore, they can't have had an intent or purpose to delay, obstruct, or prevent him from doing his investigation. And also, those same responsive and honest answers were not given to try to delay him, to hamper him, or impede him. She was answering the questions asked, and she was answering them honestly. There is nothing that in her answer that hampered or impeded him from conducting his
Me too. Let's go.
The
Wrap
moment
it up.
the shots were heard, he ran off with his gun drawn, and she didn't stop him. She let him go do his job. Well, her husband's being tased. She doesn't stop him, right? But even after all of that, he said, that wasn't why I arrested her. I arrested her for her answers to me. That was supposed to be the obstruction, those words. So you would need to believe that those words were done with a purpose to obstruct. And that they
Good to know.
He just chose not to believe her.
Thank you, Lori.
That's what happened because he heard shots being fired. But I asked him again, why didn't you believe her? And he relied on the statements or the facts that, well, shots have been reported and there was a bullet in a home. Okay. But that doesn't link to her answers being dishonest or obstructing or non-responsive. He knew those facts, but he didn't know she knew those facts. And she says she didn't know that there was a bullet in another house until much later from a different officer. And I know there's a lot of disagreement between what Deputy Fox says when he originally arrived and what Sierra says. Not a ton, but there's some slight disagreements, right? How many times it was asked, who approached whom first, what exactly was said. And unfortunately, that's the one part of this evening we don't have video of. And no fault of Deputy Fox. He said he hit his mic. It just didn't work. But we don't have that. And she says, I was responsive. She said a no, not I don't know. But even if she said no, where are they shooting? There's no one shooting. At that point, they haven't
I wish I
proven
could
she
come
heard
watch.
anyone shooting.
And dance.
So even if she said no one's shooting, to her in that moment, with her known facts, that was 100% true. They just want you to assume it's not true because a shot had been fired, so she must have heard it, which is not the burden that you're asked for a lawful verdict. They had to prove that. A hunch isn't enough. It's just not. That's not probable cause, and we don't want our police officers out there arresting people on their gut feeling. There must be evidence. And here, there wasn't. The law requires that he had facts he could articulate to justify his belief that Sierra was obstructing official business and lying to him. And he couldn't provide anything to you up here, aside from what he knew that wasn't relayed to her. And that's not enough. They have failed to prove every element of resisting arrest beyond a reasonable doubt. Instead of just talking at you, some people are visual, so I'd like to use an analogy for reasonable doubt. If you'll pardon a little bit of a professor conversation here. Imagine that there's
Like
a box.
12 times he said that.
It would be fair to assume that the cat ate the mouse. In fact, I think you could confidently say beyond a reasonable doubt.
Thank you,
There's
Darkus.
no holes in the box, no way for the mouse to get out, but the mouse is gone and the cat is still there, that the cat ate the mouse, right? This is not one of those fantastical situations that we are talking about. You could
See, that's another lie. The cat would clearly bring the mouse to you to show you the mouse first. See? He doesn't have cats.
confidently say, cat ate mouse. What if I put a hole in the box? Big enough for the mouse to get out, which actually doesn't take much. They can squeeze through almost anything. If I put that hole in the box, you can't say beyond a reasonable doubt that the cat ate the mouse, because it's reasonable that the mouse would have made it out of the hole before it was eaten.
Nope, it wouldn't have.
And that's what this case has. Holes in the box. Sierra went inside before anyone went back to the hay stalls. That's a hole. She fell asleep in her bedroom. That's another hole for the mouse. She didn't hear any gunshots at the time after she woke up before Deputy Fox arrives and they're in the driveway. Deputy Fox doesn't hear any gunshots as he's approaching before speaking with Sierra and they're in the driveway together. He didn't ask her where she had been or what she was doing before he arrived. Her answers were responsive and honest to his questions. She didn't take any action to stop him from investigating the gunshots they heard. She didn't know where Thomas and Dustin were after she woke up. She didn't until she heard rapid fire. She didn't know if there was any shooting. Deputy Fox lacked sufficient evidence to believe that she committed the crime of obstructing official business. And he didn't tell her why she was being put in handcuffs. There's a lot of holes for that mouse to get out.
Jackie, thank you. Thank you,
When
Jackie.
there's that much reasonable doubt, that means that when we come to your verdict, we've talked a lot about, I said, look, assumptions aren't evidence, and they're not. And they don't let the state meet their case, because they don't. But the one assumption is the same one we talked about before. It's not a little bit of a joke at this point of just pop quiz. She's innocent. As she sits there now. As she sat there the whole trial, innocent. She's innocent when Ms. Nicholson gets back up here for her rebuttal during jury instructions, and until you all deliberate and say otherwise, she remains presumed innocent. That's the one assumption you can make. It's the one the law requires you to make. It's just now finally to take it from a concept and a presumption and assumption and make it reality. Find her not guilty on count 2 and count 3. Thank you.
Thank you, Mr. Schuett. Any rebuttal?
Yes, Your Honor.
I missed part of that. I should start over.
Ladies and gentlemen, I want to talk to you about credibility. That's what this case comes down to, right? You've heard from Deputy Fox. You've heard from Sierra Bailey, you've heard from Dustin Bennett, you heard from Taylor, you heard from Officer Ratliff. And you need to weigh the credibility of those people so that you can determine what weight their statements are to be, whether their statements are to be believed. So let's start with Deputy Fox. He's just doing his job on September 23rd.
Thank you, Iowa. Thank you
I
so
promise
much.
you, when he started his shift, he did not ask to respond to a bullet in a 4-year-old's bedroom, to respond to Zor Road, and to be held at gunpoint. That's not what his shift involves every day. He's just doing his job, and he's trying to find the source of a bullet, a stray bullet in a house. That's a huge risk to the public, right? And his job as a deputy sheriff is to protect the people of Warren County. He's just out there doing his job. And he is met with a group of people who are not cooperative with him, are angry, obstructionists. As soon as he gets there, meet him with attitude. He asks them questions. He asks the defendant questions. He gets answers that his experience as a deputy sheriff tells him not to believe. He's hearing them and he says, this doesn't make sense. That does not add up with everything I know in my investigation.
Nice shoes.
And then he hears gunfire. And he runs to the gunfire. Because that's what deputy sheriffs do. He's got people here and an unknown source of gunfire, and his job is to stop the gunfire and protect the people. Sierra Bailey wanted you to believe, as she testified today, that she thought it odd that he ran to the gunfire.
Sure is.
That's what he's trained to do. He goes back there and he was honest with you on the stand. I had an adrenaline dump. Do I typically cuss out people when I come into contact with them? No. Am I typically running around frazzled and screaming? No.
Thank you, Todd. Thank you.
But he had just been held at gunpoint. And he said in that witness stand, time nearly stopped. He's just trying to do his job, and he is put in the middle of a very intense situation. And so then he encounters the defendant again after that, still screaming at him, yelling that nobody had guns pointed, statements he knew to be false. All of that.
Legal, thank you so much. Thank you.
She is not cooperating with that arrest. He didn't ask for that situation to escalate. But he owned his attitude and his demeanor from the witness stand. He's credible. He has no reason to manipulate the facts of what happened that night. Officer Ratliff, also just doing his job. He responds to a signal 99, a tone dropping. They know that a law enforcement officer reports being held at gunpoint, and they're not responding on their radio. There was a large police response. Officer Ratliff gets out of his car, approaches the scene to see what he needs to do, what the situation is, and he sees Sierra Bailey struggling with Deputy Fox, who's attempting to place her in handcuffs. So he runs up, he tells you what he sees, and he helps Deputy Fox place her in handcuffs. But you don't have to rely on...
Legal, I think you are one of the ones who were members for 6 months, I think. Thank you. Thank you.
Officer Ratliff's statements. You can watch his video. You don't have to rely on Deputy Fox's description of the arrest. You can watch the defendant's video. And then you can play Officer Ratliff's video.
Hi, curly girl.
Those videos both support what Deputy Fox told you. What they don't support is what the defendant told you.
This
She
judge
provided a video.
needs a lollipop.
where she's not truthful in her narration. She has a self-serving narration. For future reference, nobody pointed a gun at anybody. I didn't do anything wrong. Nobody's doing anything wrong. She's trying to spin the narrative the minute she hits record. Because she knows what she did. She knew what was going on. And so she narrates her video to her benefit. And her testimony from that stand was not consistent in any way with what Deputy Fox told you, or really what Officer Rattler told you. She has an uncertain timeline. My daughter usually goes to bed 8:30 or 9. Didn't look at a clock, but it was
Orange
dusk.
shoes.
She wants you to rely on Taylor Preston, who also told you, I saw her asleep. Well, I got home at 11 and I live 30 minutes away. Well, she confirmed she left before police get there. So she left well before. She reports the time. You can't trust her timeline. And the defendant doesn't really give you a timeline other than dusk and dark. Her daughter was asleep.
Yes. On the judge.
But none of what she's telling you is credible. The court, or Mr. Schuett, said that the state wants you to make all these assumptions. No, we want you to draw.
Hi, Vince.
This case is a circumstantial evidence case. I am not a mind reader. The state doesn't employ a mind reader to tell you exactly what Sierra Bailey knew or was thinking. In any case, unless somebody says, this is what I knew and this is what I was thinking, we have to rely on what the context is around what happens, right? And use your common sense for that. That's how life works, right? You don't know what anybody else is thinking. You use the facts, you use their actions, you use their conduct. The court is going to define circumstantial evidence as the proof of facts or circumstances by direct evidence, being testimony, being videos, from which you may reasonably infer other related or connected facts that naturally and logically follow according to the common experience of people. This is the property we're talking about. This is where the group was hanging out most of the evening. Everybody that was there that night testified to that. That's where the shooting was occurring. That is the house that was hit. And there's a call from somewhere in this area, those houses down, a little further down Grants Frederick, that report hearing shots fired. The Hannigan residence that got struck reported hearing shots fired. Now, I didn't give you the distance of how far the Hannigan residence is or how far that other dispatch came from. But just from looking at this aerial representation, and you have another angle of it from the defendant, they are way further away. And gunfire at 9, 10 o'clock at night, probably not super common. They heard the gunfire. You heard Dustin Bennett tell you there were 50 to 75 rounds fired. And Deputy Fox told you that after he heard like that, once gunfire started happening while he was on the property, there were dozens of shots. He didn't tell you there were 75 shots. So the defendant wants you to believe that she is in her 80-year-old farmhouse, sleeping with her infant, and has no concept that there's gunfire, multiple shots of gunfire happening outside her home. That she had no concept when she went outside that they were in the back shooting. That she had no concept where they even were when Deputy Fox approached. That she had no idea why Deputy Fox approached. That Deputy Fox never told her there'd been a stray bullet in a house.
It was almost a murder trial.
That Deputy Fox was angry and mean as soon as he approached. That Deputy Fox ran back, yelling bloodbath, before tasing her husband.
Should I go to the verdict?
Deputy Fox pretty much the whole time.
Or should I keep going with her closing statement?
Ladies and gentlemen, that's just not logical. And I want you to think about the timeline you've heard of how Deputy Fox got there. He responded within 3 to 4 minutes to the Hannigan residence upon the dispatch. He's there for 5 minutes and responds. You can see, probably takes him a minute or two to get to Zor Road after leaving the Hannigan residence. So we're talking
Court please is again in session. You may be seated.
This is quick.
We're back on the record, State of Ohio versus Sierra Bailey, case number 23CR41016. It's 4:16 p.m. The jury is in the courtroom. Has the jury reached a verdict?
Yes, sir.
Would you please hand it to the bailiff?
If the glove doesn't fit, you must acquit.
Case 23CR41016, State of Ohio versus Sierra Bailey. We, the jury, find the defendant, Sierra Bailey, not guilty. That is signed by all 12 members of the jury, dated today's date. Is today the 27th? Okay. June 27, 2020. Today's the 28th.
we didn't have our phones.
Case number 23CR41016. We, the jury, find the defendant, Sierra Bailey, not guilty of resisting arrest. So it's not guilty on both counts. I need the foreman to change this date to.
I feel she clearly resisted arrest. I just feel that she clearly resisted arrest. I feel she lied to the officer and then she pulled away from the officer. And whether it was a legal arrest, warrantless, he said you're under the arrest or didn't. A bullet went into a 4-year-old's house. They were the ones that were shooting the gun. You know, I feel that this judge just let other people who want to be a Karen to just go ahead and do it because it's not, you're not going to get in trouble for it. But that's what we have juries for. We have juries, and that we live in America. So she's fine. She gets to go home now. She didn't take the plea deal, which I probably would have. I don't know. Thank you so much, Sally. Thank you. Have a good 4th of July. All right, now we're going to go into Fleischer. Let's go watch a little bit of Fleischer today. Can we just do that 20-second clip one more time? It's really funny. I'm doing it.
Your Honor, on Mr. Williamson,
Oh my gosh, I've been talking to myself this entire time, and I am so sorry. And Miss Douglas, I really apologize. Court Magistrate, Miss Shive as well. I really apologize for that.
Sorry.
I've been talking.
I'm sorry. I love that.
So that's where we are.
So unfortunately, poor Logan and Pavel tested positive for COVID. So they're both at home, clearly dying. You were going to see them this whole time. Okay. So Logan, you're going to see blowing, sneezing, coughing. Pavel's just like chill. He's chill the whole time until he talks. Then you can then you can hear his voice. His voice is terrible. I mean, you could just tell it's terrible. Lucifer. Yeah, we're gonna see Lucifer. And yeah, Logan's cow. Listen, I'm not 100% sure how many shots of Lucifer I got. I mean, he was there a lot, but I didn't. Well, I'm not going to show you the entire docket. So hopefully I got Lucifer. It's not. If not, I'm going to go find him, and we'll get to see his beautiful kitty. Yeah. See, I mean, they are. Spade, I played it twice because it was so funny. They are both sick. They are just both sick. And um, did I play the clip? I think I did. Remember, Red Red went to physically went to this courtroom a couple days ago to watch this court. He was right by these guys the whole time. I hope he's not going to get sick too. See? Yeah, that's what happens sometimes. You never know. All right. Here we go.
He apparently looks like he tried to pass it. He didn't make it by 6 questions. It's okay. Talk to the judge.
Why did you fit? What happened?
I don't know. I think like I pressured myself too much. So I asked him if I could try to do the quiz again.
It's not me. It's
You can do the quiz again. I expect that you're going to do it again so that you can pass it.
Yes, sir.
How many times have you taken it?
I took it 2 times, but the second time I failed by 7 questions.
I mean, you're close, man.
Yes, sir.
When do you want to take it again?
And I was thinking about taking it today, like the GED, but I was like, nah, I'm gonna give myself more time, probably like 1 more week to study. And
Do you actually have the books to study?
now I gotta get the book, but I've been doing it like on.
online.
Yes, sir.
Oh, it's okay. I want to know, what are you doing?
Like
You seem to study. You can't,
it's because I'm gonna pull it out.
It's okay.
Sure. I'm studying on language arts right now.
Okay. You have to do something different than what you've doing before.
Yes, sir.
Because if you're doing the same thing, it's not going to work again. You're going to continue to fail it. Something has to change for you to be able to pass it.
Yes, sir.
Usually that would mean getting books, reading over it and studying so you get the material so that you can pass it. It's not rocket science. It's not that difficult. It's literally a matter of you sitting down, reading it and committing it to your memory.
Yes, Your Honor.
So I'm setting off 2 weeks and I want to know that you pass between now and 2 weeks.
Yes, sir.
Study for 1 week, take it the next week, and I want to see that you pass. Do you understand? Okay. All right, 2 weeks, Victoria.
Go Netherlands.
Good morning, young man.
This is just David Fleischer.
How are you?
Good, how are you?
How old are you?
I'm 16, turning 17.
Fantastic. What are you doing? Are you in high school?
Yeah, I'm about to be, I think I'm a senior. At Dulles High School.
You said Dulles? Wonderful. You're in great hands.
Keep telling them that, y'all need to stop lying to them.
It's great. It's a great profession. You know, if you treat it well, it pays dividends. It really does. I mean, no one can mess with you when you know stuff. And when you're a lawyer, you know stuff because you learned it, right? That's
That
what you do in
means
school. You
everybody
spend
can
12
mess
hours
with
a day
me.
learning. And when you know stuff, people can take you for a ride, you know, and you get money. That's what life's about, right?
We're gonna sit back, I'm gonna let them watch how things operate here. We've been up in felony court, I'm assuming, let them say I'm misdemeanor court.
Yeah, I mean, you should also, if you're really interested, come on a Friday because that's usually our busiest day. And then you see really what goes on here, other than trials, you know, but Fridays are the best days. You should come back. You're welcome here anytime. Thank you so much. Sure.
He goes
Yeah.
with you.
Benjamin Perry. He was, yeah, KPS for a while. They just picked him up. That's why he's so old. He was on a PTI. Failed to report. He thought just staying away from her was the problem. So that's why it's that age. I want to see if the state will re-rip her, see if we can't come to a conclusion because he's so young with that family violence. That's like a life sentence to me.
I'm okay with doing whatever you want to do.
I just want to get her re-ripped, see if he's had any issues with her and possibly get that part of the complaint removed so I can just focus on his future. He's not thinking about it now, but if he's 40 and
I'm
trying to,
understand.
so.
He's in custody now,
He's
right?
in custody now.
You bring out Mr. Perry? Thanks.
And then we'll learn our lesson.
Remember, two are Spanish. Huh?
Yes. No, I was last time, there was none. Like Dr. Schmidt, Judge?
No, I don't have any.
Hi, Melissa. Hi, Victoria. Hi, Stephen.
It's too much stuff. I know.
Don't smack the judge.
I'm just kidding.
No, I need to clean it up. It's a mess.
Clean on Monday, please? That's why.
No, but that's not, that's a personal letter. That's not. Oh, crap.
I was just showing Victoria and Melissa. Stephen.
Morning, Mr. Perry. How's jail? How is it?
Don't like it.
Sucks, right?
Yes, sir.
Good. It's supposed to suck. It's not there for you to have fun. Only thing you got to do is show up. And when you fail to show up, the only thing that happens, your bond goes higher and higher and higher. And now, because you continually fail to show up, I can't trust you to do things on your own. So that's why we got you here now. You've got a bulldog fighting for you now to try to get you the best thing you can get. I don't know what's going on with your case now, but Trinidad, how long you want?
3 weeks, so I can get, I mean, so they can, whatever's transitioning with this.
So is
Logan's on the case, but I mean.
Logan, is discovery complete on Mr. Perry's case?
Yes, Your Honor. I'll try to re-rip her this afternoon.
Okay. You want two?
Yeah,
Okay. Sorry, sometimes these things take time, but gotta understand Rome wasn't built in a day.
That was pretty
Next time,
cool.
Show up. Good things happen when you do.
I can put you in timeout, Fozzie. Go tomorrow, or no, today. No, I won't. I won't.
Well, I mean, there's a bond set, but I'm not giving him a PR bond. He don't show up.
Understand.
Yeah, okay. Ralph,
And since he's being charged with ABI, there wouldn't be an affirmative finding. I'm not sure if there was some confusion there, but it's just an ABI, not an AFM.
There's no court today,
A
Fozzie.
charge.
I don't know if you knew that or not. I thought initially it was a family member, but yeah, it's an ABI. Just garden variety. Okay.
Darkest, I really can't.
Hi.
I can't put Fozzie in
Judge, I
timeout.
have Kevin Cabrera on the docket
Hi,
this
Terry.
morning. There's a bond violation.
Come up, Mr. Cabrera.
Supposedly, I think he didn't go do a drug test when he was supposed to. That's what I think. I'm not really sure. I didn't see, I haven't talked, there's nobody here with the pretrial people or bond people.
Thank you, Fozzie.
Right. Mr. Cabrera was called to go do a drug test and he failed to do that. You ever do that, I will revoke your bond, put you in jail. You will be stuck like Chuck until this thing's over with. I'm now sending you for a drug test because I want to know what's in your system. Go ahead, take a seat for me. Mr. Reyes, if you want, Ms. Garza, on Cicero, is discovery complete? If you just want to set it off for a bit.
On Los Cicero, Judge, the discovery is complete and shared.
See, he sounds
Set it off for a couple weeks,
horrible.
so we can back and we can talk.
Poor guy.
Yeah, okay. Alan, you ready? Ms. Mitchell, good morning.
Morning.
How's jail? You know, you were in custody now because we let you out. While you were out, you picked up a felony case and then you also picked up another assault case. And the problem is this seems to be a continuing problem, a continual problem where it's assault after criminal mischief, after assault, after criminal mischief. Where do we go from here?
She does have a history of bipolar and schizophrenia.
Okay.
And at the time of one of the incidents, she was being treated for that. So she was in the state of a manic state at the time.
Let's see, I don't even know. Do you mind, Ms. Garza, reading what happened on the newest assault, please?
On the felony one?
No, on ours. They're out of the same transaction, so they're one and
They're not, Judge. They're two different transactions, two different dates. The peace officer is June 30th. The ABI is June 15th.
They both filed it on the same, July 1st it was filed.
Okay, but they're different dates.
Yes.
Got it. So what happened? You want to repeat it? Yeah, go for it.
2024 in Harris County, Texas, officers were dispatched to Ben Taub Hospital after a death report call.
Hi, Jay
On
Fire.
arrival, officers made contact with the complainant, who stated that while she was talking to the X-ray technician, the defendant, who was a hospital patient, suddenly punched the complaining witness in the face, straight to the nose with a closed fist. The complaining witness stated that she felt pain. Witnesses corroborated the complaining witness's statement.
Okay, so the felony assault against a peace officer, was that also at hospital as well?
That's whenever she was booked for criminal mischief, and the police officer walked by her and she stood up and
It was at JPC, Judge.
Got it. I mean, it just, you know, we let her out, she picks up a new case and then she can't, not even at the JPC, unable to. I'm gonna deny your PR bond for now, Ms. Mitchell, because quite frankly, I mean, you scare me. We let you out and you continue to pick up cases. So.
Bad.
Your bond right now, it's low as it is. It's 2,500. I guess, let's see what happens in the felony court and then we'll go from there. I am ordering you as a condition of your bond not to have any contact with any of the complaining witnesses in these cases and not to be in possession of weapons, man. Okay, thank you.
Thank you.
Thanks. No. Okay, I'm ready when you are.
He's not on docket.
I see the cause number, 251-2247.
15 days with 5 days credit.
Make sure you allow gifting.
And is the trap on both? Or
There's Monica
which-
and
is
Monica
one being
M.
dismissed? What are we doing?
There's two.
The trespass.
Okay. Mr. Robles, you're now charged with 2 cases. You're charged with driving while intoxicated. You're also charged with criminal trespass. You've worked out an agreement where they're offering you 15 days in jail on the DWI. His bowl cut is tight, guys.
That's almost a perfect bowl.
with 5 days credit. Understand as part of this agreement, the criminal trespass will be dismissed. You now have 1, 2, 3, 4, 5, 6, 7, 8 priors on your record. One thing after the other. If now the DWI is going on your record. If you ever get pulled over in a car, do you think any officer is going to be nice to you? Do you think they're going to search you the minute they pull you over? Do you think they're going to harass you? I guarantee all 3 things are going to happen to you anytime you're in a car, even if you're a passenger. So if I were you, I would never have a hold of anything that you shouldn't have. If you were driving in a car, I wouldn't even step in it remotely if you have even half of a beer.
Challenge accepted.
Half a glass of wine, a shot of anything, because the remote smell of anything funny is going to land you back in here. And I'm telling you, what we're doing today will not happen again. From now on, it's a minimum of 90 days in jail. Do you understand?
Yes, Your Honor.
Don't ever get in a car if you have even a drop of alcohol or anything to smoke, because I'm telling you, you're going to be right back over here. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you accept this agreement today, Mr. Robles, the DWI will go on your record. It's going to be there forever. I'm telling you, anytime you get pulled over, they're going to harass the crap out of you. Don't give them a reason to put you in jail. You understand?
Yes, Your Honor.
How do you plead to this offense, sir?
Thanks, Eileen.
It is time served. It's 15 days, credit for 5, so you're not going to have any time. But from now on, it's a minimum of 90 days. It only goes up from there.
Thanks,
If
RW.
you haven't gotten the message with the 8 prior charges, I will bring the pain next time you're here. You understand? You get out there, don't make boneheaded moves, because you come back here, I'm going to light you up. I'm going to suspend your license for 180 days. Do not drive until you get a license. Good luck to you, sir.
Thank you, Your Honor.
Thanks, sir.
Thank you, Your Honor.
I know you want to review this. She's come back from saying that she's picking up these charges. She's not looking at all. She's not able.
So what I'm going to do is I'm going to send her home with one so that she can redo another. Okay, I'll send her home with one.
I need one right now.
To bless
Yeah,
you.
give her one and we'll send it home.
Poor Logan.
Sorry, Judge. You want to send her home and have her come back anytime?
Correct.
Yes, sir.
And then it shows now that he was released from custody.
There's Victoria.
So April was asking for Tuesday to try to get a hold of him to bring him in.
His bond is at 10,002 on our case, 1,000 on the other one, and now he picked up a new felony where it's 25,000. They give him a PR bond on those
I
cases?
couldn't tell. I'm assuming it's a surety because nothing was imaged. Well, from this morning.
And I have a hired lawyer on the tamper.
That's why everything. Oh, yes, because council.
Don't push the kitty away.
Okay, so
Bring
he's
the
withdrawn.
kitty back.
Got it, okay.
Oh, so that's
Keep
probably why. I
on
couldn't see
everything he posted sureties?
on the case that I have for this court, 10,002.
He posted surety? Got it, okay.
So they'll probably give them the 70.
Lucifer. Lucifer.
So once they publish that document, I'll be able to see the court date and then I'll.
Mhm, mhm.
What's the period Thursday?
Bring the kitty back.
I don't know.
County employee.
Hey, hey.
Did I send you an email? Did you see the one I sent? No, I haven't seen anything. I'll chill up now.
Okay, that's here.
I'm the person.
There's the first back. Look at his little look. Really?
Mr. Jenkins, come up. Pavel, can I give you this cause number, please?
Yes, sir.
251-6665. So, Mr. Jenkins, you were charged with assault of a family member. The magistrate ordered you to get a GPS monitor. Are you telling me that you didn't go get it? Yes or no?
What's it gonna be, boy? Guys, all the new guys in chat, type where you're from. Like Pennsylvania would be the best thing to type. Just type where you're from.
When was it due to be on by?
To get it per his officer. But the conditions were for the magistrate. He didn't see you. He doesn't have an attorney.
Okay, you were conditioned by the magistrate to get it today. If you do not have it by business and today, guess what's gonna happen? What? Correct. And what's gonna happen then? Correct. So you're on your way. Go get the monitor. If you do not, things are not gonna go well. And don't argue with the staff why you don't need it. I don't care why you think you don't need it. It doesn't matter. A court order is a court order. And when you don't follow court orders, bad things, good things don't happen to you.
I was just here just to see,
I'm not going to talk with you about this. The magistrate put it on.
Right.
So you need to put it on. You understand? You have until the end of today. And if you don't get it on, I will issue a warrant for your arrest. Please take a seat.
Is it cold? Is it cold where you are?
That's jail. So let me get this right. In Harris County alone, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21 different cases. You pick up and you get life on an engaging case in Montgomery County, and they parole you out. And now you've picked up a theft case and an assault case.
Thank you so much, Sergeant from Alaska, Sergeant Franklin.
So on a life sentence, you do 13 actual years. When did you get out?
November 1st, 2023.
So 6 months later, an assault and a theft case. And you want me to give you a PR bond? You know, when I've got 4 kids, I love my kids to death, right? And when my kids mess up, I say, come on, Alex, stop it. Okay, Dad. And he says, okay, I'm not going to do it again. And then he does it again. And then if I don't do anything, what happens? Does it again. And then I found the only way I get through to him, there has to be some kind of
Me
consequence.
too.
Because what happens if he keeps saying sorry and then does it again? Sorry, does it again. Sorry, does it again. 21 times? Has he gotten it? Mr. Smith.
That's my
after
kids.
21 sorries. Has he gotten it? Have you gotten it? Freaking life sentence. And now here, it's a theft of a cell phone, right? Tell me about this. Tell me about the theft.
Because they're both out of the same transaction. From what the DIM state is that on June 18th, the officer responded to a residence located at 2555 Grand Canyon Drive in reference to a family disturbance call for service. Complaining witness advised on the date.
Cat
she was with the
videos?
defendant in a vehicle when defendant saw complaining witness' boyfriend calling her. Complaining witness advised she's in an intimate relationship with the defendant. Complaining witness had stated that she was upset with the defendant. Complaining witness advised the defendant took possession of her cell phone and refused to give it back. Stated the defendant dropped her off at a residence and she used her daughter's cell phone to find the location of her cell phone. Complaining witness stated her cell phone was pinging at the residence where the defendant was located at. She arrived and made contact with the defendant through the gated door. Defendant was holding onto the gate while speaking to each other, and as she requested her cell phone back, the complaining witness stated that the defendant refused to give her her cell phone and hit her with an open hand strike to the left side of her face, causing her pain. She said that she did feel pain, but did not want to pursue charges at the time.
Because she wanted a cell phone back. Mr. Smith, should I give you a PR bond? Sorry?
Sure, that's your choice, Judge.
If I may?
Sure.
I spoke to the complaining witness and the witness on this matter. They have both recanted their statements. The complaining witness has stated, knowing the charges that could be filed against her for falsifying her report to a police officer, she stated that she did lie about the situation that she was being, she just lied about the situation as a whole. I talked to both the witness and complaining witness again, just right now, and they both stated that they,
Do you have a
again,
911 call or anything like that?
that's the only thing we're waiting on. That's why we cannot dismiss this case. We have to do a full evaluation, especially.
I'd like to know if there's a 911 and if they corroborate what initially happened on the day in question, right?
Yes, Judge.
You know, we don't ask for much in Harris County. You know, I don't know about Montgomery County, how they do things, but all we want our streets to be safe. And I would be remiss to think that you were even lucky to be out in the free world when you get a life sentence. You're even lucky to be out. And now you want me to, after I've admonished my kid 21 times, now you want another PR bond? Ain't gonna happen, dude. At some point, we'll get through to you that it can't just continue like this. But I can't in good conscience give you a PR bond when you are on parole for a life sentence. And now you've picked up these two cases. You know, the sad thing is that your bond really, it's only $100. The only thing that's keeping you in at this point is $100.
Does she know him? I think she's scared. I think she just changed her mind because she's scared of him. And she's right. I don't know if she knows him or not. So I think they were on a bus and he took her phone and she grabbed her daughter's phone and did like find my device and went to his house and said, "Can I have my phone back?" And he smacked her. Is she his girlfriend?
And I hope at some point, Mr. Smith, you do get it before you do get a life sentence that truly keeps you in for the rest of your life. All right. Thanks. Thanks, Tim. Hey, so how long, Shreya, do you want to set this off like quick? So that
Logan
we
is
can,
so
how long do you think
nice.
you can get?
So right now, the Harris County Sheriff's Department is taking up to 3 months on getting us 911 calls. The issue is that if we keep asking for expedited 911 calls, everything becomes expedited because every division.
And I get it. So what I would say, set up a trial, right?
Huh?
How old are you?
18.
Why did you miss court?
Because I wake up late. I didn't put the timer.
Not a good thing, Miss Useda.
Oh.
Have you ever played Monopoly?
No.
You never played Monopoly?
Nope.
Man, where are you living, under a rock?
No, I haven't played the game. I haven't played the game.
Okay, in the game, you're gonna do another one.
Okay.
Come back, and then we'll meet with Mr. Slider to figure out what we're gonna do, man.
Yes, sir.
If you leave,
No.
I'm gonna make your bond really high. You will not be getting out.
Yes, sir. Yeah.
Thank you, Mr. Slider.
Thank you, Judge.
Yes, can you bring out one more?
I was made a mod in Judge Fleischer's chat, and I was recording. I thought I'd killed two birds with one stone, but then I had an issue. I clicked the wrong. I lost my mouse. I clicked. It rewound the video for a second, or fast forward the video for a second while I was trying to delete a comment, and it looks like I skipped part of her. But you know that happens. I'm a professional.
One person, please. Macklemore.
Sorry.
Thanks, Stephen. You're the best.
Judge, can I bring up Mr. Colbert? It's an off docket. He just has a bond question he wants to ask you.
Sure.
Hey, Mr. Colbert, come on up. Basically, this is the young man that his family.
Do you have a cause number?
Yes, I do, Judge. I apologize. Should have given that to you. It is 249-3894.
Did you get that, ADAs?
ADAs, we're just requesting for him to be able to go to Memphis to live. That's where his family is.
We have Memphis in here.
Few charges here in our court.
No, you have an open criminal mischief that you've taken off on me 4 different times, a harassment that you've taken off 4 different times, an unlawful carrying of a weapon, that's 5,004, and now you pick up a DWI, and you want me to let you go out of state where I can't monitor you? Really? You want a back rub too?
No, sir, I was on the accident because
Yes,
I have family
please.
that I have better support. And I
No, you are a flight risk, Mr. Colbert, and you don't follow bond conditions. You do what you want to do. And I'm going to tell you now, if you go out there and you take off, the next time I'm going to make your bond quadruple. Do you understand?
Sir.
No.
I'm not, I want to still be on my monitor. I want to still be able to do everything. I want to still, like, I can take a drug test right
Need
now.
to
I'm
do-
following all guidelines.
To do is settle your cases here so you can move on with your life, because these things will trail you forever. I don't know who you hang out with in, where's it, Memphis you want to go?
This is where I'm originally from.
Okay, I don't know who you're hanging out with. I don't know what you're doing. I can't keep close tabs on you. So you could be out in the middle of the night, I wouldn't even know. And I can't rein you in at a moment's notice where I can't hear. You have 4 open cases. You repeatedly take off on me. Trust is built in time and with actions, not words. And you have your DWI from June. It's not even been a month yet. It's been 2.5 weeks, and you want me to let you go? No. No. Thank you.
I'm on the verge of being homeless, sir.
Steven got your back rub for you. Don't worry.
There's always a way when you put your heart to it, Mr. Colbert. Just because you tell me you're homeless doesn't mean that I'm going to let you go 15 hours away where I can't stay close to you. You have very serious cases that are dangerous cases.
That's
I don't know
Logan,
what you're going to do over there.
prosecutor.
No. I want you here until we get done with these cases. Where, I mean, where
I'm
are
trying,
we?
Judge. I'm trying to get that ASAP. It's just this.
Understand, the more cases you pick up, the more difficult it makes it for everybody involved. And the more time it takes to get evidence. If you find it difficult now, it's because it takes time to get evidence. You now have 4 open cases, so that quadruples the amount of evidence that John has to get. Don't blame it on him. It's me. And I'm going to keep you close to here until we're done.
So what do I do about my living situation?
Well, we're going to talk and we're going to try to get you
Plenty of
programs.
places that you can go to around here in Houston if you have nowhere else to go. There are.
So you want me to be homeless and I have a support
Say
system?
that. Don't blame this on me. I mean, you picked up 4 cases, not
Trying to
me.
help you. You're not going to win this war.
You're the one that's been a flight risk 4 different times beforehand, not me.
Just let me talk to Marshawn and we'll get him some help. We'll get him all the shelters. We'll get him everything.
I have, or the MAC has social services that they can help you with if you need. They can help you with housing, food, clothes. They have social services to help you if you really need it. But I don't want you going to Memphis with 4 open cases.
That
I don't have any travel restrictions.
that is Pittsburgh, right, guys? Is that the Pittsburgh Pirate? Right? Am I crazy, or is that Pittsburgh Pirate baseball team? Somebody who watches sports ball, tell me if that's right.
On my thing, so
I'm telling you now, no. And if you go, it's a direct violation of your bond, and I will issue 4 different warrants, and I'm going to make all of your bonds 20,000 and fine. Do you understand? You are on notice now, and I'm going to make a docket notation because I have so many other cases that I can't remember everything. So that way I can remember everything. Okay, thank you. Please. You give me that look again, I'll hold you in contempt, Mr. Colbert.
Yeah, I saw the back. That's not Pittsburgh. I would like to go there. Poor Pavel. Poor Logan. Go to bed. Time out time. Go to the corner. Interesting.
Okay. All right, so you were Mr. McLemore, correct?
Yes, sir.
So, Mr. McLemore, you, I guess it's come to my attention that Sonia is telling me that you want me to set you a bond.
Yes, sir.
Okay, understand, sir, I don't know you. I may have met you once back in 2019 when you had a fugitive case, but other than that,
I kept thinking
don't know
that
what
too.
you've been up to. I don't know where you've gone. I don't know how many cases you picked up. I don't know your criminal history. I know that you're gonna tell me it's little bunnies jumping in the woods and everything's just like little teacups and raindrops and rainbows, but I've never met you. The only way I get to know you is the paperwork, because that tells me who you really are.
Sir.
So, Mr. Kim, what's he wanted for and from where?
Your Honor, he's wanted a Breckenridge County, Kentucky for 5 charges: engaging in organized crime, receiving stolen property, $100,000 or more, theft by unlawful taking and disposition of all others, between $10,000 to $1 million, first degree criminal mischief, and possession of burglary tools. State would be opposed to a bond. He has a current local charge of felon possession of a weapon, and he has been charged with 2 other states in Utah and Louisiana, where he has at one point racked up 227 charges simultaneously.
227 charges all at the same time?
But he was only convicted for 1. I guess the way they split it up in the NCIC is it was just the number of thefts and burglaries, but the way they enter it in the charge literal.
Okay, that's true, guys. So my sister is a thief. She's a burglar. She's a freaking thief, a criminal, unbelievable. She burglarized this house once, right? And they made a list of everything that she took from this house and charged her for each item. She had 99 charges, and some of the things on the list were like Band-Aids, Q-tips, paper towels. 99 charges she got from that one burglary. And then she was charged with burglary. Like, she only was charged for one thing. But that's true. That happens.
They put each count. So I don't know why they did that, but it's the first time I've seen it with that kind of breakdown.
Wow.
That said, he was recently convicted of that one and served 4 years prison, and his parole ended just last year there. He was also convicted in Utah, where his sentence there recently ended in 2022, I think. So he's a felon multiple times over. He's a true habitual.
What's going on with all the like different states and thefts? Is it?
He's just been charged with, I mean, it's 54 pages of NCIC.
But what is it though? Is it
for
fuel theft? Is it, a cigarette truck that they're different states? Is it?
For Louisiana, I'll just go by groupings, otherwise it's gonna get a little chaotic. Simple burglary, damage to property under $1,000, theft of a firearm, theft under $1,000,
And so what did we have here with the 2019 fugitive?
that was when he was wanted out of Louisiana for had it open. He was wanted for theft of motor vehicle, criminal damage to property, theft of firearm, theft of goods. So that's probably what was nested in with what he was wanted for before. He's also bond forfeited out of our local in 2018, and those resolved in 2019. So he's already responded.
It's the wrong lid.
So they would be opposed to those 6 reasons.
Do you want to?
My client has informed me that he has a job at Amazon, waiting on him if he's able to get a bond. He says that he has spoken with officials in Kentucky regarding the bond there. I believe it's $100,000. And he says that he has people who could post that. So he would like a bond so that he can handle his business in Kentucky and begin working at Amazon.
So Macklemore, you scare me, man. Truly, the amount of charges that you have, the amount of charges in different states that you picked up.
It was just a story on the
I'd be
news.
scared to let you go. I mean, I think that, sometimes we have to protect people
I'll
from
look.
themselves
I'll
because they're
look.
their own worst enemy, right? I'm sorry?
No, I can assure like that wouldn't happen no more because now I have a 5-year-old daughter and I have her full time now. So it's like I wouldn't even have.
You have a full-time 5-year-old.
That's
My
just
Lord. Be careful, man, because I'm telling you what, when you have a kid, the apple doesn't fall far from the tree. Let me ask you, would you want your daughter to be like you?
No, sir.
Don't take custody of her, man, because I'm telling you, if you have full-time custody of her, she's gonna end up like you.
I'll find
And
it
if
for
you don't want her
part
to be
2.
like you, I'm telling you. Yeah, I'm sorry, Mr. McLemore, it's just way too much drama. I can't give you a bond. It's just, with as much as you're wanted for, I think that you'd be a very, very big flight risk.
And my bonding condition is my unlawful care. They putting me on a GPS monitor for 24 hours, so I wouldn't be able to do nothing anyway.
I get you, and I don't think that would be appropriate to give him a bond. Just too much drama. Yeah, sorry, Mr. McLemore. But good luck to you, sir. And be careful with that child, man.
All right, Mr. McLemore, we're gonna come back to this later.
Okay, now.
Thank you, son.
Your Honor.
Okay, so that's what I had from the docket today. There was a high-profile case, and I don't know if the cameras were on for it. I don't know. I didn't look yet. But I think it was the police chief or something got a DUI. I think it was somebody. It was either the police chief or the head prosecutor got a DUI and was coming in for arraignment today. So I'm gonna find it if he showed it, if the cameras were on, which I don't see why they wouldn't be. I'm pretty sure he got $100 bond for it. So I'll do that when I play the next half. So Judge Fleischer is off today. So I'll either play part of yesterday's during my next stream or I'll find it and I'll do that during the next stream. So that's what we got today. I'm gonna have since all these memberships happened, I'm gonna put a video up in the members only area today. That's just hilarious. It's just so good. The whole thing is just so good. I think it's like 30 minutes long if I had a guess. It's not much longer than 30 minutes. And it's just going to be like a preview. So I'm going to put it in the members area first so that you can see it first, and then I'll release it to the public in like, I don't know, 2 weeks. That sounds right, right? Hello. All right. So I am going to hop into Discord for a little bit though. Take a little break before I do that video, and I will talk to everybody in Discord. Thank you so much for coming out today. Thank you so much for all the gifted memberships and super chats and stickers and everything. I really appreciate it. Thank you so much. And I hope to see you in Discord. Come and talk to me in Discord. You don't have to talk in Discord. You can just chat if you want to. But I'm going to be down in the vocal vibrations room if anybody wants to talk. Or you could just type. Just come. Bye-bye.